So, what are some presumptions in California legislation and state statutes ultimately? There are a handful of bills each year considered by the California legislature that create a so called presumption in state law. What exactly is a presumption? Basically, a presumption in law is a conclusion that's drawn based upon specified facts until that fact has been rebutted. With a presumption, a party does not have to actually prove the fact that's being presumed. Instead, the burden shifts to the other party to disprove the fact or to rebut it. There can also be different standards required to rebut a particular presumption in California law. So I have some examples drawn from recent legislation that you might have seen in California bills. For example, this subdivision creates a presumption of affecting the burden of producing evidence and may be rebutted by clear and convincing evidence showing blank. Or this presumption is disputable and may be controverted by other evidence, but unless so controverted, this evidence is bound to, or a court is, or an agency is bound to find in accordance with it. Another example is this presumption may only be rebutted by a preponderance of the evidence. To overcome the presumption set forth, the court shall find that, and then it's explained. So presumptions can also be used in different laws, including, for example, criminal laws found in the California Penal Code. For example, some activity creates a presumption of insufficient mens rea to accomplish the offense. On the other hand, a presumption could also be prohibited from being used in the criminal context. For example, in another provision, it says this presumption is a presumption affecting the burden of proof, but it does not apply in a criminal action. Now, in some state statutes, the legislature determines what type of evidence is or is not sufficient to overcome the presumption. For example, in one provision, it says a written declaration or testimony from a blank is not sufficient to rebut the presumption of liability of the respective parties. So what happens when the other party rebuts the presumption? That can be addressed in statute or not addressed. And we have examples of doing so. If a court finds the presumption is rebutted, it shall provide its reasons on the record, is taken from an existing statute. So in all these examples, there's a particular reason why the legislature chose to create a statutory or legal presumption in the law. The presumption benefits one party and places a greater burden on the other party to overcome that presumption. In some statutes, the California legislature has designated the standard of evidence that the party attempting to overcome the presumption must actually meet. And as you could hear, these presumptions can be used in both the civil and criminal law context in the state of California.